facts, to prove on a, to show, sorry, I'm just reading wrong here, the appellant to discharge on the alleged new facts, and if offset it against the seriousness of the offences, considerations of the evidence as it previously stood, and cumulatively tantamounted to exceptional circumstances warranting the appellant's release from custody. So there was no need for the state to have to submit evidence in rebuttal, as the state was involved in the matter in respect of the quote quo initial bail application, and that evidence would still have to be considered with the evidence on new facts. So this was not a new bail application. This was a, I would like to call it a supplementary bail application, but on these new facts, which the state did not need to rebut if it was not discharged by the appellant insofar as proving these new facts were exceptional. According to the appellant's counsel, his personal circumstances, his medical condition, his financial obligation to his family and responsibility to his employees suffice to establish exceptional circumstances to warrant his release from custody. The presiding magistrate erred in not granting the appellant bail on the new facts. The appellant indicated that the investigations were finalized. The likelihood of the allegation of influencing the witnesses was no longer an issue. He was not a flight risk. He qualified to be released from bail, and if the appeal court found that the refusal of bail was wrong and not in the interest of justice, that he be further detained, he was capable of raising the amount of 100,000 as indicated, which could be used for the purposes of bail, including further conditions like reporting, surrendering his passport, and making himself available for investigation purposes. Now, in his affidavit, he mentioned his life partner and child were solely dependent on him financially, and he was the sole breadwinner. Now, this the court took cognizance of in respect of the affidavit that was submitted at his initial bail application, where he placed before the court factors him and that he was supporting. Now, he failed to disclose that his life partner was employed by his business in a managerial position, responsible for the finances of the business in his initial bail application. He failed to disclose the amount he was earning and paying to her as an employee. He failed to mention that amidst his incarceration, his business was operational, including his winning of awards, which finances, if any, was being managed by his life partner and business manager, who on his affidavit amidst being his manager, Mr. Reuben Mola, who was partly reliant on the appellant as well as partly reliant on his grandmother's pension for his financial support. But again, the details of this employee's earnings and the shortfalls of the money that he now has based on this new circumstance was not disclosed. These facts were germane to the appellant, and the same would have had bearing on his financial position deteriorating. How much income was he currently generating as a musical star? How much of these funds were being utilized? This has particular bearing on the allegation of financial dependence on public for his financial funding, again, with amounts that are unknown. For the appellant's life partner and child to be evicted because of the circumstances of the bills not being paid, one would need to know what the financial circumstances of the business of the appellant was insofar as the income that it's currently generating. And if it was generating zero, that should have been brought to the attention of the court in the quota quo bail application on new facts. But none of this was mentioned. The inability to spend quality time with family, including his newborn child, is circumstances that is a reality and consequence of his detention, flowing from the various charges he was facing, and unfortunately applies to all awaiting trial inmates. From the record, he is not the primary caregiver to his newborn, and as defined by the case law, in the case of S versus M, Center for Child Law, Amicus Curiae, 2008 3 SA 232, and as well as the case that was handed up to court by counsel for the appellant during the argument, his relationship with his child is that of a father. Yes, he is special to the child, but he's not the primary caregiver. His life partner is the primary caregiver. So the circumstances differed materially from the cases that was being cited to be reliant upon as far as consideration for the release of the appellant. Though the court can identify and appreciate his emotional circumstances, that cannot elevate his circumstances to qualify as exceptional. Moreover, no evidence was tendered from the appellant's side, from the social workers, from any person indicating the impact that this psychological disconnect with his child would have on this child. The case of S versus M gave various aspects that the court needed to consider if the court was to consider the release of an accused, and this was in sentencing stage as far as punishment went. If this person was the primary caregiver, being the mother of the child, how and who was going to take care of this child during the child's upbringing. Now, in his affidavit, he sought the court to appreciate that he was self-employed in the music industry, yet failed further to explain what exactly that entailed concerning the income generated by his fame as a musician outside of his live performances. Now, he indicated that he had 4 employees and their families to maintain, without explaining how much each employee currently earned, what exactly their employment status was, that their support and well-being was solely dependent on him, what was the current situation in respect of their earnings. In this regard, he also won an award for, I think actually 2 awards, one for Best Music Star and there was Best Song, I think, but no indication, in as much as it was drawn to the court's attention, in court of quo as well as in the appeal court, no attention was given concerning whether or not these awards came with it any financial benefit, which one would expect to be the case if one is winning awards. There is also the aspect of royalties, which one would earn as a music star without needing to necessarily work and perform at this moment in time. But be that as it may, these aspects germane to the appellant do not come to the fore. He indicated that he suffered from an injury to his leg requiring urgent medical intervention. Help. This was also an issue that was canvassed during the bail application on new facts, where the issue of whether it was a Schedule 1, Schedule 2, or Schedule 5 drug that was going to be required was again not properly ventilated with the person that would have best known what the medical situation was, but tried to be canvassed with the appellant. Obviously is not a medical practitioner, so he would not have had the relevant knowledge pertaining to this particular medication. But be that as it may, this is the first aspect that was not completely and properly ventilated, inasmuch as the appellant highlighted his medical condition. And I'm taking also reference back to what previously said by this court in respect to the medical condition. This is outside of his psychological need for intervention and assistance, which was not attended to whilst his during his incarceration, as was previously highlighted. Again, this aspect was not even a thought when the documentation was submitted to correctional services insofar as what medical attention, if any, the appellant required from counsel for him. And this was done just during the beginning stages of the application of facts. The respondent submitted that there was no evidence in the appellant's case assessed totally in the interest of justice would tantamount to new facts, and even if same was considered as such, it would not tantamount to exceptional circumstances. The learned magistrate followed the right procedure and was transparent in the application. There was no misdirection in refusing bail. Now, having regards to the arguments raised by the appellant and respondent and considered the application in totality, including the record quo in the initial bail application, the quota quo in the bail application on new facts, the heads of arguments submitted by the parties, the supplementary heads of arguments submitted by the parties, as well as the appeal itself. The allegations against the appellant consist of a number of charges. The one relevant to the proceedings, which was based on the DPP's instructions to prosecute the appellant on the various charges and centralize these offences to be prosecuted at the Polokwane Regional Court, where the case has since been transferred. The appellant took umbrage with the manner in which the DPP reinstated the various charges, as well as the centralization in respect of the bail application. Unfortunately, as indicated previously, the status dominus litis, it has the power to determine whether or not a citizen of South Africa is to be prosecuted or not, and for what offence. Withdrawal of a charge is not the end of the matter. The matter only becomes res judicata, as argued by the appellant, once the accused person is acquitted or convicted and sentenced. This court finds no fault with the manner in which the state elected to proceed, and that decision can be ventilated if the appellant so sought through litigation in terms of parja or legality review, if the appellant was unhappy with the decision made by the state in respect of the centralization. The quota quo ventilated the circumstances in respect of the J50 warrant of arrest, which was signed by the presiding officer who ultimately dealt with the application and the bail application on new facts. As much as it may have appeared to the appellant as perceived bias, this was not canvassed as a basis for recusal of the presiding officer in respect of the bail application on new facts. I've dealt with this aspect earlier as well, concerning the letter that was submitted to the state by counsel for the appellant, indicating that there would be a possibility of a discussion in respect of the recusal of the presiding officer. This, fortunately, never came to the fore and never featured in the bail application in any form, way, or manner on new facts, which, inasmuch as it was raised as an point in limine, it should have been the foundation for the recusal, because if the appellant perceived that the court was biased and that the court, because of his conduct in signing the J50 warrant of arrest and initial bail application refused by him, he could not bear a neutral mind to the matter, the appellant had every right at the onset of this new application to seek the recusal of the presiding magistrate. This was not done. To state in court at the time that the court was addressed on appeal that the views expressed by the quota quo in judgment was of such a nature that his bias was blatant and that it was too late at that stage to seek recusal, unfortunately, cannot hold weight. This is facts known, germane to the appellant, germane to counsel for the appellant, should have been ventilated by the appellant at the correct time, which was before that second application was even heard. Having regard to the arguments raised by the appellant and respondent concerning the application in totality, the court took note of the fact that the presiding magistrate considered the provisions of Section 60 of Act 51 of 1977 with specific reference to all the requirements needed to be satisfied for the appellant to be considered as a candidate suitable to be released on bail. It was argued that his personal circumstances were of such a nature that it tantamounted to new facts warranting exceptional circumstances to justify his release, and these aspects were also considered by the presiding magistrate. The grounds of appeal was premised on the appellant's medical condition, which was alleged to have not been magistrate. I have to disagree and align myself with the contents of the record and arguments raised by the respondent, as well as the documentary evidence that was ascertained from the record. For one's medical condition to be appreciated, it would be required complete disclosure of information which is unique to oneself at the time of approaching the court. This was disclosed at the initial hearing. The aspect of the Department of Correctional Services not rendering assistance was only canvassed just prior and during the second application, and nowhere in the record did it appear as if the Department of Correctional Services was refusing treatment. Therefore, this allegation cannot transform to a new fact justifying exceptional circumstances, especially in light of the fact that these aspects were known to the appellant and were placed before the court already in the initial application. The same is noted concerning his financial affairs. He failed to take the court into his confidence concerning his and his life partner's income and expenditure, to the extent that same was unknown and could not be relied upon when determining the impact of his detention on his life partner and family. The respondent correctly noted that the appellant failed to take the court into his confidence concerning the nature of his business, the staff complement, the earning, and most importantly, what is the current financial position of the business, its assets, and the income generated by his business. To merely allege that his staff and family would suffer by his incarceration without explaining anything pertaining to this business, unfortunately, is of little assistance to the court. His evidence concerning the repayment of the deposit for the show he failed to fulfill impacting on his financial position, and this was part of his affidavit in support of his bail application on new facts, where he alleged that he had to refund all the people that shows were cancelled due to his incarceration, was contradicted by the legal proceedings instituted against him, flowing from the refund not having been paid in respect of his non-performance of his contractual obligations. Therefore, the court is left in a position of uncertainty as to whether or not he was taking the court into his total confidence when he explained how he was financially now in a dire situation because he had to pay back all the people that he could not perform for, and then the proof that he hasn't paid back a particular person rebuts that and puts aspersions to that allegation. The court had regard to what was said in Tibula, where the strength and weakness of the state's case was ventilated, and as there it was highlighted that regardless of the strength of the state's case or the weakness of the state's case, this is but a factor that the court must take into consideration. And it was clear that from the evidence that was placed before the court in the application itself for bail, new facts, as well as in the appeal record from the previous hearing, there was a number of matters wherein the appellant was involved in, and wherein, for whatever reason, was either withdrawn due to reconciliation or mediation, or withdrawn due to reasons merely handed in as exhibits, and the fact that the DPP has decided to bring all these matters together for the purposes of centralizing could only be to the advantage of the appellant. The court would be remiss not to note the alleged delay in the regional court concerning finalizing matters, the number of cases on that court roll, and that this was an alleged new fact warranting release. This again was canvassed with counsel in court at the time that counsel addressed court, wherein the circumstances surrounding the plight that the appellant may have with this undue delay in his finalization of his case, and then the fact that the counsel for the appellant was unaware that there was various courts that sit as regional courts in respect of the proceedings. But from the heads of argument, the court gauged the fact that this was not necessarily the situation, but rather that particularly the Polokwane Regional Court would take an excessive amount of time to ventilate this particular trial. Now, for record purposes, I must take cognizance of the fact that this particular matter, from the period of his arrest, his bail application and transfer to the regional court, occurred within a very short space of time. That is an extremely unusual set of circumstances. I can take judicial note of the fact that in the cases that was referred to me, where the period in custody awaiting trial was that of durations over 3 years and over 2 years, and that it could be seen as a serious prejudice. From the argument that was raised by the appellant, it was clearly speculative, especially in light of the fact that the purpose of the centralization of the charges was to ensure for the speedy finalization of the case against the appellant. And amidst the allegation that the cases were not proceeding due to witnesses not being interested in pursuing the charges, there is a duty on the state to ensure that justice is not only done, but seen to be done. And no one, regardless of their standing, can ever be said to be above the law. I'm of the view that the appellant failed to take the court into confidence in the first instance, nor in the appeal court, nor in this application on bail on new facts, which was placed before the appeal court after its refusal. He did not take the court into his confidence concerning various aspects raised above. Amidst the alleged weak state's case, he failed, amidst the new facts being raised, to place exceptional circumstances before the court to warrant his release, with specific reference to his affidavit, evidence in support of his release, as well as the various arguments that were raised in respect of the appeal, as well as the application on new facts. In the final analysis, the order of the magistrate refusing the admission of the appellant's bail cannot be said to have been wrong, as cumulatively all the facts raised did not establish exceptional circumstances justified in terms of Section 60. The requirements of Section 65(4) of the Act was thus not met. In the result, the appeal against the refusal of bail is dismissed.
Scott, please.
The court shall adjourn